I have read your comments, YouTube. You want one video to succinctly sum up the status and the nature of the attacks and battle lines involving the legality of pistol braces? Here we go. All right, so we had the massive Fifth Circuit Court of Appeals decision. Really quickly, the injunction remains in place. The circuit court said that, look, we're probably going to sign with the plaintiffs, but only on one particular issue. They never even talked about other issues that were raised. What are all those issues? They ultimately kicked it back down to the district court. I did a whole video about why and all the different ins and outs of that. But just to quickly sum up, if you didn't catch that video, injunction remains in place, but only for the people that we're talking about. So in this particular case, FPC members who are qualified, as well as maximum defense customers. And now we're back down to the district court. But the big thing that came out of that is the fact that the Fifth Circuit Court of Appeals said, look, we're likely going to wind up ruling on, or at least we're heavily leaning that way when it comes to one particular legal issue in favor of the plaintiffs. The plaintiffs are the good guys contesting the rules. And then I read your comments in that video, and a lot of people were saying basically, what's going on here? Give it to me in even straighter English, and this is me trying to do that. There are 4 battle lines across all these different lawsuits if you look at these lawsuits. Here are the 4 battle lines. The first one is the APA argument, which stands for the Administrative Procedures Act. The APA argument basically deals with whether or not the ATF properly complied with federal law when they first published their notice of the rule. In other words, they had to put out a notice of this is what we're looking at. They did this back in 2022 of this is what we're probably going to be looking at. And then people get to comment and they have to respond to those comments. Then, as long as what they pose as the actual final rule, that's what they posted up on January 31st. It has to be a logical outgrowth. It has to be reasonably foreseeable that whatever ultimately winds up in the final rule has that nexus, has that connection to the proposed rule. If they do that, then you're good. If they don't do that, then we have a potential issue for an APA violation. That was basically what the Fifth Circuit Court ruled on when we're talking about Mock v. Garland, all right? It's all APA issues. And the gist of that, again, was that the ATF in their proposed rule was talking everything was centered around worksheet 4999. And then at the end of the day, they basically jettisoned that. And then ultimately they came out with the 6-factor analysis, which, by the way, was completely non-determinative, i.e., and this is what the ATF said. This isn't me making it up. I have to chuckle. I'm sorry. It's too crazy. I have to chuckle. The ATF's own factors were non-determinative according to what they said. Ultimately, everything has to be decided on a case-by-case basis. And interestingly enough, every single case-by-case basis they provided, they determined that everything was an SBR. But again, not the purpose of this video. We're talking about the 4 big issues and how do things connect together. The way that this would work is that if the plaintiffs, we're talking about the APA violation, if the plaintiffs were to win on a summary judgment motion, summary judgments are things that typically both sides move for in a civil case. So we're not talking a criminal case, we're talking about a civil case like this. And they're saying, look, judge, we're just so right. We don't have to go through everything. Just give it to us in summary judgment. All right. That's kind of the equivalent of the teams line up, you play a quarter or if that, and then you say, we don't even have to play the rest of the game. We're going to win. If one of the good guys wins on the APA issue, the whole rule gets struck down. It doesn't matter if we're in the Northern District Court of Texas. It doesn't matter where we are. The whole rule gets struck down. That's the good news. The bad news is there's nothing that would necessarily prevent the ATF from curing the issue. In other words, they just go out, they copy paste the final rule into a proposed rule. They put that new proposed rule back up. They've got to go through the whole comment and response process that can easily last 6, 8, 10, even 12 months, give or take, who knows, but trying to give you some timelines to work with. And then they could just republish the final rule. So that's the pros and cons to this, all right? You can win, you can get the whole thing thrown out, but it's something that the ATF could cure. Now, while everything was down, of course, the rule's no longer in effect at that point. So presumably, people could manufacture, sell, possess, do all those things as if the rule does not exist. We'll have to see what the district court chooses to do. The fact of the matter is the Fifth Circuit has basically said in writing, and when I say basically, I mean explicitly said in writing, look, we're likely going to rule that this was a violation of the Administrative Procedures Act. That's a strong signal to maybe a district court judge Go ahead, take the leap. We've got you. Now, rest assured as well that, look, people can appeal that. The ATF, the DOJ can appeal that. So we'll have to see how that whole thing goes. But that's the first issue that really that entire case was boiled down to by the Fifth Circuit. And you notice we didn't really talk about anything else. There's 3 other big issues here. We didn't talk about any of those. To understand why, we need to understand something called the constitutional avoidance doctrine. This is a general doctrine that's out there for courts to always consider in way of, look, if we've got a constitutional issue and if we have a non-constitutional issue, so if we have an APA, Administrative Procedures Act issue, and then if we have a Second Amendment issue, if the court can make a ruling without going into the constitutional issue, they ought to do so. So presumably the lack of going into the Second Amendment and some of those other issues that were being raised, both in this case as well as in other lawsuits against the pistol brace rule, was done so for the reason of the constitutional avoidance doctrine. I know that was a question I kept seeing coming up in the comment section. All right, so the first issue is we got APA, you got the upsides, the downsides. One base hit can basically knock out the whole rule, but the ATF can cure it. So some good, some bad. Number 2, another big issue on this, and again, there's 4, is the fact that the ATF is exceeding statutory authority. So this is another common feature to these lawsuits out there against the pistol brace rule. What are we talking about? Understand that anytime an administrative agency, and there's over 400 agencies and sub-agencies out there in the United States, I'm not asking you to like that, I'm just observing it as a fact. Anytime they interpret a rule, there's a question as to whether or not they have exceeded the statutory authority. So we're talking about whether or not their interpretation is interpretive. In other words, look, we're really just interpreting, clearing things up, and kind of prescribing certain boundaries that are quite reasonable and conservative and narrow and definitely fits within the meaning of statute. Or are they legislative? In other words, look, we are binding people to law. We are binding things. We're changing massive outcomes. Now, understandably, the plaintiffs are saying this is legislative. The pistol brace rule is legislative. You are fundamentally moving the lines on where SBR interpretation happens. And the ATF is saying, no, we're not. This is just interpretive. We didn't change a single short-barreled rifle statute out there on the books. We're just giving guidance and interpretation. As I pointed out in my video yesterday or a few days ago, linked below, when you're in prison, that feels reasonably legislative to me. That doesn't feel so interpretive. The judges in the Fifth Circuit strongly agreed. But nonetheless, that's a second issue, all right, as to whether or not the ATF exceeded their statutory authority when they issued the pistol brace rule. A third issue to many but not all these lawsuits is just a straight up Second Amendment challenge saying, look, show me where under the Bruin test, that's the one that comes out of June 2022, which among other things stands for the premise that if the government is wishing to regulate a protected Second Amendment activity, then they need to show how their regulation, their law, fits within the nation's historical tradition of regulating firearm laws. Okay? So that's basically a vanilla, straight-up Second Amendment challenge to this. There's nothing fancy. It's a fastball over the middle of the plate of, look, this is what we're arguing here. Second Amendment issue. Can you defeat this ATF or not? The fourth issue is the rule of lenity, Lenity, the rule of lenity, which is something that if you've been a longtime viewer of my channel, you know that I keep bringing up over and over and over again as I'm doing so here. The rule of lenity is reasonably simple. It comes out of common law. In other words, you may not necessarily find it in your state statute book somewhere, but it is a doctrine that the U.S. Supreme Court, as well as the Fifth Circuit Court of Appeals and others, has really been using frequently over the last about 30 or so years. And it goes far back before that. The rule of lenity, the short version is this. We don't want tyranny. Tyranny bad. What's a common feature to many different tyrannical regimes? They have vague laws that are criminalizing things, and that allows them to basically go out and hit people, throw them in jail. And if the laws are vague enough that if the person who might be charged with them doesn't even understand when they can comply, when they shouldn't comply, i.e., if I look at a statute and I don't understand based on that statute what's criminal here, what isn't. If there's too many ways of interpreting that, that can often lead to defenses in court against that particular law or rule. That's the rule of lenity. If we have different reasonable interpretations of a criminal statute, then the interpretation, provided that's reasonable, must go to the criminal defendant in court. So there's basically a rule of lenity issue. Now, you can argue some or all of these in court. You don't have to just file a lawsuit and only choose one to go with. Different lawsuits have different features as far as what they're arguing. Some lawsuits are doing all four, others are doing 2 or 3 of the 4. All right. If you want more details about going into more depth about what the parties are arguing on one side or the other, for instance, on the Second Amendment issue, the exceeding statutory authority issue, or the rule lenity issue, let me know. The video that we did a few days ago, which again is linked in the description box below, I really went in depth on that first issue, the APA issue, which is the issue that the Fifth Circuit went into. So I don't want to spend too much time going through that again. But if you do want to see more in depth, let me know. Guys, before I get to the ever popular quote of the day, I just want to also throw out there as well that if there's enough interest for me to cover what are some of the more right-leaning or left-leaning circuit courts, federal circuit courts of appeals, I'd be happy to do so. Let me know that in the video as well. Also, if you've not already done so, one of the best ways to help out this channel is just to click like. It tells the algorithm other people should see this video, and it tells me you got something out of this. And frankly, as you've not already figured out, we change what we do based on what you want and what you say we should do. So I read the comments. I can't read all of them necessarily, but I do my best to always read through those. So thank you very much for sticking around this long. Now to the quote of the day. The bravest sight in the world is to see a great man struggling against adversity. That's from Seneca the Younger. Thanks again, and as always, I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.